Welcome to Building Families, Bridging Differences, a family law journey.
Hey everyone, welcome back to an all-new episode of Building Families, Bridging Differences, a family law journey with my friend and attorney, Shelly Booth-Cooley. I am your host, Mike Leon. You know, Shelly here is a certified family law specialist and the founder of Cooley Law Firm out in Las Vegas, Nevada. And she focuses exclusively on family law, helping clients with whether it be divorce, custody, adoption, and assisted reproduction. And she's really known for her compassionate, straightforward approach. Today's episode, we're going to be talking about alimony and spousal support in the state of Nevada, what it is, when it's considered, and how courts decide what's fair during and especially after a divorce. Shelly, it's good to see you as always. Someone out there listening to this, they're trying to get the basics, wrap their head around this. How do you kind of describe what alimony or spousal support is meant to address, especially in a Nevada divorce?
Well, thank you for having me, Mike. And that is a very good question. So first off, let's talk about the naming. Alimony and spousal support are the same exact thing. They are synonyms. You can refer to alimony or spousal support. No difference. So for basics, alimony is money that's paid by one spouse to the other after separation or divorce. The purpose is to help the receiving spouse maintain financial stability and to help them transition to self-sufficiency when one spouse earns significantly more than the other spouse.
So let me ask you, Shelly, because in the last episode, we did a little bit of math in the state of Nevada, which you hate doing. And
Yes.
my understanding is, though, that Nevada doesn't necessarily have like a strict formula on the child support part of this, or maybe they do, you can explain. But what are some of the main factors the court is looking at when they're deciding what type of, if the support is appropriate on the child support front?
Okay, so we're mixing terms. So child support and alimony are two different things. Child support is support of children, and that is based on a statutory formula. Alimony, we do not have a formula in Nevada. There isn't one. We've got approximations as to what the court does, but there isn't a formula. We have fairness-based factors to determine whether alimony is appropriate, how much, and for how long. And based on an attorney's experience, they often have a better idea of what a judge may or may not do as far as alimony awards. However, even that is a difficult situation because it also depends on each judge. Some judges are more pro-alimony versus other judges. So when you are looking at that type of a situation, there's a lot of factors that come into play to determine whether or not alimony is something that a court might consider.
This is why we have you on the show. You're the lawyer to explain all this. So let me ask you, when a client comes to you and they show you the income differences, I'm sure it's a common concern that you hear about. How do you explain to them how the court kind of evaluates each spouse's ability to pay versus the other spouse's needs?
Okay, so one of the things we look at is on a very basic level is we look at the spouse's income, obviously. That is the very first factor that we look at. What is each spouse's income? Then we look at what is the duration of the marriage. If the parties have been married for 25 years versus 1 year, we are looking at a very different situation. We also look at things like the financial condition of each spouse. So in addition to income, what or other financial resources does each spouse have access to? And that's when a premarital or postmarital agreement, the assets and debts in that agreement, that's where that may come into play. The nature and value of the property owned by each spouse, during the marriage. Each spouse's contribution to community property And that includes financial and non-financial contributions. And by non-financial contributions, that's a keyword for a homemaker or a stay-at-home parent. We look at length of the marriage. Again, a short-term marriage, there's probably not going to be much, if any, support unless the incomes are very different. Then we may have a very short-term obligation versus a long-term marriage. We're going to possibly have a lifetime award of alimony. We look at the income, earning capacity, age, and health of each spouse, contributions as a homemaker or caregiver for the family. That is one specific factor that we look at that also is covered in a number of the other factors. So career sacrifices are very important to the alimony consideration. What was the standard of living during the marriage? What is the career or employment history of the spouse who may receive alimony? If you have a spouse who was an attorney and the parties agreed that one of them, the attorney, would be the primary caregiver and was out of the field for a number of years, then what type of an award do we need to help that spouse re-enter the workforce? We look at education, training, and job skills developed by each spouse during the marriage. So for instance, if a spouse obtained their MBA during the marriage, which enabled them to be a high income earner or a higher income earner, then the court's definitely going to take that into consideration when making an award of alimony. And then again, this touches on the previous factor, but whether one spouse supported the other's education or career advancement. So while one spouse is attending school, the other spouse worked and took care of the children and made sure that the house was operational so that the other spouse could focus on their education. We look at the property that is awarded to each spouse in the divorce, the physical and mental health of each spouse, and then we also have our catch-all, any other factor that the court deems relevant to fairness, which means that family court is a court of equity. So any other issues that may be relevant and important for the court to consider, we can raise it and present evidence as to that factor.
Shelly, can I ask you about temporary support? Because I've heard that term, or at least I've seen that used, especially during a divorce. And I know that's obviously different than longer term support. Can you kind of explain what tends to distinguish those two different stages?
Okay, so we have a couple different types of alimony. So we have temporary alimony, which is support during the divorce to cover immediate needs like housing, health insurance, the mortgage, possibly rent, and living expenses, basic living expenses. We have rehabilitative alimony, which is short-term support to help a spouse return to school, re-enter the workforce, and obtain training. And when we have a rehabilitative alimony award, we need to make sure that we include terms that specify what the spouse will be doing, where they'll be attending school or training, and the time frame that the training has to be completed. Because the last thing we want is for a spouse to have a rehabilitative alimony award and for there not to be a time frame that this other spouse has to complete the training, and 5 years post-divorce, the spouse decides to go back to school and the other spouse is on the hook. So it's really important when we have a rehabilitative alimony award, that we put some deadlines in place so that there's compliance. We have permanent or long-term alimony, and that type of support is granted after long-term marriages where one spouse cannot reasonably regain financial independence due to their age, health, or other circumstances. And then the last type is we have lump sum alimony, which is a single payment or property transfer in place of monthly payments.
Shelly, a second ago, you mentioned about the length of the marriage. You said like a 1 year marriage versus a 25-year one is going to be vastly different in terms of the alimony support. So, like, can you kind of explain a little bit more? How does the duration of the relationship kind of influence the type and the amount of support the court's going to consider?
Yes, absolutely. So marriages that are over 20 years are long-term marriages, no question. Even marriages that are over 10 years I wouldn't consider that a long-term marriage, but it's definitely a longer-term marriage. A lot of marriages don't make it to 10 years. So a 10-year marriage is a reasonably long length of time. If we're talking about marriages that are 5 years or less, that's a short-term marriage, and the likelihood of getting any type of post-divorce alimony is going to be much smaller, and it's going to be very, very fact specific as to what, if any, type of alimony is awarded. With that type of a situation, you might be looking at some temporary support to get the other party on their feet and to get them stable so then they can start earning income and supporting themselves.
Shelly, what about couples that decide to kind of circumvent this system and try to privately negotiate this stuff? What should people out there understand about creating their own agreements with respect to going through a divorce and alimony support?
Well, the court and public policy promote settlement and informally resolving issues when you are able. For most folks, it's easier, and it's an easier pill to swallow when both parties come up with a mutually agreeable resolution than to have a judge basically jam one down your throat, right? So it is absolutely encouraged. What I think is a good idea is if you are in a situation where there's a large discrepancy in income, it is a really good idea to at least talk to an attorney so that you can get some general ideas as to what type of award, if any, and what a court would likely to do in your specific circumstance, if for no other reason than to help guide your discussions.
Yeah.
Knowledge is power. I think that's a Schoolhouse Rock motto. Knowledge is power, and you can never have too much knowledge. So, read, research, and the best way to research an issue is to talk to an expert. Attorneys are experts in family law. This is what we do. So talk to an attorney, find out what a court is likely to do, so that even if you're not going to have an attorney represent you, at least you have the knowledge and information so that you can protect yourself and help ensure that your future is going to be secure.
Yeah, conjunction junction. Once your function is also another one. Shelly, we'll leave that there. But for someone that's listening to this right now, as we put a bow on this episode, and unfortunately they're preparing for a divorce, they're worried about the spousal support angle and all the things that you kind of mentioned and broke down. What other information is helpful for them to start gathering early on so they can truly understand their options?
Information regarding assets and debts is going to be helpful. Information regarding what each party owns, what each party earns, other sources of income, if there's passive income streams, any sort of information that you think may be helpful in resolving your matter and helping the court make a decision is going to help your attorney better evaluate your case so that they can provide you the best information possible.
Well said. Shelly, thank you so much for the time, the insights. We appreciate it as always.
Thank you for having me, Mike.
And thank you to everyone out there for listening to this installment of Building Families, Bridging Differences, a family law journey. If you want to learn more or even schedule a consultation with Shelly and her team, do me a favor right now. Visit CooleyLawLV.com. Don't forget to like, subscribe, leave a review, comment, share the episode with someone who needs to hear it. I'm Mike Leon. We will see everybody next time.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.